evening, everyone. And my name is Marina Surgeries. Welcome to Garden Court's talk this evening. Thank you all for joining us today on what is the last of Garden Court's talks to mark International Women's Day. Our topic is homelessness and fleeing domestic abuse. Is law and policy keeping pace? There are, I'm told, nearly 400 people who've registered for this talk, which I think may be a new record for Garden Court. But what that does show is the importance of this topic and discussion, particularly against the backdrop of the harrowing numbers, the increasing numbers of domestic abuse cases in the last year. We are very fortunate to have some brilliant speakers this evening, and as time is short, I want to get straight into introducing them and hearing their talks, of course. But before I do so, I'm afraid there are some housekeeping matters that I just have to go through with you before we start. So the webinar is being recorded, and what that means is only the audio and video of the panelists will be recorded. This webinar may be shared on our marketing channels, including our website and social media. Any slides will be circulated to registered delegates after the webinar. We will take questions, of course. I'm sure there will be lots of questions, but we will do that at the end of the talk. And if you want to ask any questions, please put your question in the Q&A box at the bottom of your screens. And Justine, Compton and I will take questions at the end. Now, of course, with that many people who have registered for this talk, I don't think we're going to be able to get through all of them, but we will, of course, do our very best to take as many questions as we can. If you have any technical issues, again, please put them in the question and answer box. And again, Justine and I will do our best to answer them. So turning to our speakers and our brilliant panelists, first to speak is Justine Compton. Justine is a former solicitor, currently a deputy district judge and a barrister at Garden Court with over 20 years experience in specialising in housing and homelessness and possessions, regularly instructed by the official solicitor. Justine will briefly outline the current legislation relating to domestic abuse, referred to in the current legislation as violence, but it is domestic abuse under the new legislation bill, and why a change in the law is so needed. We will then hear from Chris McCurley, who will take us through the key change of the domestic abuse bill, focusing on definition of domestic abuse, protection orders and priority need. Chris is a partner at Ben Hall Bell Solicitors and specialises in working with victims of domestic abuse. She gave evidence on the serious deficiencies of the domestic abuse bill at the UN-CEDAW inquiry into the UK government in 2019 and has been actively involved as a witness throughout the bill's passage through Parliament. She is a member of the Resolution Domestic Abuse Committee and is a resolution's national lead for all forms of harmful practice. I will then say a few words about the domestic abuse bill and what it doesn't do. Of course, it's a good bill, but it certainly doesn't go far enough. I should say that I'm also a barrister at Garden Court Chambers with 20 years experience specialising in housing and homelessness, and co-chair of the Housing Law Practitioners Association. Our third speaker is Pragna Patel, who needs no introduction. Pragna is a founding member of Southall Black Sisters Advocacy and Campaign Centre, and for over 40 years, Pragna has been at the forefront of the Southall Black Sisters' most important and pivotal cases and campaigns involving domestic violence, immigration and religious fundamentalism. Pragna has written extensively on race, gender and religion, and Pragna will talk about the Southall Black Sisters' experiences of working with abused women with no recourse to public funds and their efforts to enshrine better protection for such women in the domestic abuse bill. Our last speaker, Sue James, who has spoken at our seminars before, formerly director and solicitor at Hammersmith and Fulham Law Centre, specialising in housing law. She is a founding trustee at Ealing Law Centre and was Legal Aid Lawyer of the Year for outstanding achievement in 2017. Sue recently co-authored a book with Simon Mullins on housing possession duty desk and rights and legal aid and access to justice. And she has recently been appointed as CEO of the Legal Action Group. Sue will be talking about and addressing legal issues in a holistic way, how people don't have single issues in life, but life events, and intersection of legal and other problems. For survivors of domestic abuse, this often means problems with housing, income, welfare benefits, as well as the need for protection. It's a real honour to be sharing this platform with such inspiring individuals. So I'm not going to keep talking, I'm going to let others do the talking, and we're going to start with Justine.
Thanks very much, Marina. So I'm going to be doing a whistle-stop tour of the present legislation, the current homelessness legislation in the context of those fleeing domestic violence, with the aim of identifying where there is a lack of existing protection and why some new legislation is needed. But just before I start, a startling statistic that was on the government website that I noticed today. This statistic has probably got even worse since the pandemic, but domestic abuse is the third most common cause of homelessness. And between January and December 2019, so pre-pandemic, 25,000 households lost their settled accommodation due to domestic abuse. So that for me really highlighted the difficulties that survivors of abuse face and what a critical issue it is in terms of the link between domestic violence and homelessness. So just moving through my slides, starting at slide 1. The homelessness provisions are contained in Part 7 of the Housing Act 1996. And these are the provisions set out there which must be satisfied before a duty is owed to any person before they can be accommodated by a local authority. There is also the Code of Guidance 2018, which supports the statute. It is statutory guidance, and Section 182 of the Housing Act 1996 requires local authorities to have regard to this statutory guidance, but clearly it is only to have regard, it is not a statute. Now, the duties that are owed to those that satisfy the conditions vary. They can range from simple advice and assistance to a full duty to accommodate an applicant. Now, clearly, we all know that there is a shortage of social housing, and it has to be said it's a long and arduous road to being accommodated, and of course, local authorities have a difficult task in terms of ensuring that they carry out their duties properly, but also that there is enough social housing to go round. And whilst I represent applicants and those fleeing domestic violence, for example, and I do not represent local authorities, I know that we are joined today by a number of local authority officers. And I simply say this at the start, my comments are based on my experience and the cases that I have dealt with. And whilst I may be critical, I'm sure there are some local authorities that are doing a very good job and are doing their best to implement the guidance, particularly in case of domestic violence. So just to say, in terms of the Code of Guidance, Chapter 21 specifically deals with domestic violence, and obviously that is the go-to chapter in terms of dealing with domestic violence cases in terms of homelessness. So just moving on to slide 2, before I go into the hurdles that have to be jumped through by any applicant, not just those fleeing violence, but all applicants, there is a fundamental flaw in the homelessness legislation when it comes to domestic violence applicants. And that is, there is no statutory definition. Historically, the definition that has been applied to cases where survivors are fleeing violence and presenting themselves to local authorities has been based on physical abuse. And of course, that has been the case in society. It's not been recognised until fairly recently that domestic violence consists of all manner of violence, not just those that leave the bruises and the scars physically. The seminal case of Yemshaw and London Borough of Hounslow in 2011 gave the opportunity for the Supreme Court to consider the definition of domestic violence in a homelessness context. And the brilliant Baroness Hale made it clear that the definition to be applied in homelessness cases was to be exactly the same as that applied in family law cases. And you can see from the slide that domestic violence was held to include physical violence, threatening or intimidating behaviour, and any other form of abuse which directly or indirectly may give rise to a risk of harm. And the wider definition now appears in Chapter 21 of the Code of Guidance, and that incorporates emotional, psychological, and financial abuse, all of which are obviously relevant to the wider definition of domestic violence. So now moving through, and I will do this very quickly, the hurdles that all applicants have to get over, but my focus clearly will be on those that are fleeing domestic violence. So a person has to establish that they're homeless, obviously, that they're eligible. I won't be dealing with that part, and I know the panel will be dealing with those who do not have recourse to public funds later in this webinar. They have to be in priority need, and they have to not be intentionally homeless, in other words, not have made themselves homeless. And survivors of domestic violence do not get any preferential treatment and are required, just as any other applicant has to fit within the same criteria as all other applicants. So moving on to the next slide, which is the section 177 of the Act. There is a deeming provision which lends some assistance to those fleeing violence, and that is can be found under section 1771. So if it is probable that continued occupation will lead to violence against the applicant or the applicant's household, the accommodation is deemed to be unreasonable to continue to occupy. And the applicant will be regarded as homeless. So they will have passed the first hurdle. Now, there are some issues arising out of that deeming provision. What does probable mean? What does violence mean? And how does the applicant evidence this? Now, there are some safeguards in the code that can be found in Chapter 21 in terms of how the local authority makes its inquiries and how it interviews and treats the applicant. There is a recognition in the code that third parties, such as the police or social services, may not be involved. Importantly, there is no need for violence to have already occurred for this deeming provision to apply. And steps to mitigate, such as non-molestation orders, panic alarms, whilst they are advised to be pursued, there is no obligation on the applicant to pursue those in order to mitigate the risk. So that all sounds very positive, very helpful to those that are applying, having left their accommodation due to domestic abuse. But it's not quite as a happy situation as it might seem. And I'm going to move on to the next slide now to explain the problems that certainly I have experienced, having seen a large number of decisions and worked with a large number of clients who have been fleeing domestic violence and have been seeking accommodation. So whilst the Act and the Code appear to be benevolent and helpful to survivors, there are definitely problems that are encountered by applicants in this situation. Now, the existence of domestic violence in its broadest sense is still not being recognised by local authorities. A restrictive interpretation is applied, and almost always evidence is sought of some kind of physical violence as the marker of how serious this violence and abuse might be. Emotional, financial and coercive control is very much underplayed and categorised as relationship breakdown or relationship difficulties. They're phrases I have seen in decision notices, saying that whilst it might have been unpleasant, this does not amount to abuse. And the more subtle signs of domestic violence are missed. It seems to me that unless an applicant arrives at a local authority office and almost sings from the rooftops that she is fleeing violence, it is not picked up on easily by the local authority officers. Often an incorrect test is applied. You'll recall it's probable. And evidence of past physical violence and an imminent risk of future physical violence is often sought. The test is probability, not certainty, and that is where local authorities, in my view, go wrong. And it's generally a very unsympathetic approach is adopted by local authorities. And perhaps if I can just give an example of one of the cases I dealt with. You may be aware that where things become very serious in domestic abuse cases, it can often be referred to what's called a MARAC, which is a multi-agency risk assessment conference. And that is where all number of third-party agencies will get together and assess what risk is faced by a particular person facing domestic violence. And in a particular case I dealt with, my client said she couldn't remain in her accommodation because the perpetrator was soon to be released from prison and he knew where she lived. So she needed to be rehoused. And even the evidence that she was at risk of serious harm, that was the assessment made by MARAC, was not enough to satisfy the local authority that it was not reasonable to continue to occupy the address and the accommodation that the perpetrator knew of. So I don't think I'm being harsh based on the evidence I've seen that local authorities are not really understanding and getting to grips with the terrible circumstances that those survivors face, and not appreciating the courage it takes for one to leave their settled accommodation and actually seek help from a local authority. So moving to the next slide, and the next hurdle to jump is priority need. No automatic priority is given, even if domestic violence is accepted and proven. What an applicant must show in order to be in priority need, and of course there is no duty if there is no priority need, no duty to accommodate. An applicant must be vulnerable by reason of a mental or physical health issue or other special reason, and that is not an easy test to satisfy. And so survivors of abuse would need to demonstrate that firstly they had a mental or physical health condition, and secondly that they were rendered vulnerable as a result of those conditions. There is a requirement to meet this test, really to provide medical evidence showing a mental or physical effect from abuse. And that presents particular problems in circumstances where a survivor may not have contacted a third party, may not have divulged anything to their GP for understandable circumstances. They may not have contacted the police, they may not have contacted social services, and therefore evidentially it's extremely difficult to show that the person is in priority need. And I give an example of a client who was not, this was not a domestic violence case, but it took 3 attempts to persuade a local authority to accept that an applicant was in priority need, who had sought to commit suicide repeatedly. And the local authority found that even with that mental health condition, the requirements of Section 189 were not satisfied. So just moving to the next slide, please. So as I've said, evidence is a significant problem, and of course, evidentially, it's going to be extremely difficult to produce anything, particularly contemporaneously, because often just getting to the next stage of leaving the property is one thing. To then go and get help and perhaps counselling and other assistance may come much, much later. It may be years later before a survivor can face seeking medical assistance to deal with the trauma that they have been through. But in the absence of that evidence, then no housing duty will be owed. And this is where the Domestic Abuse hopefully Act bill will really assist survivors and applicants, because a separate category of priority need hopefully will appear, and hopefully will enable there to be a freestanding category to ensure that survivors will be deemed in priority need, and that will help them enormously in terms of being accommodated. And I have to say at this point, the work of Liz Davis, my colleague at Garden Court Chambers, who is also on the panel today, along with Crisis, has been absolutely vital in securing this provision, which was not originally in the bill. And I think it's sterling work that this has been achieved. So I know that Chris is going to talk more about that particular provision shortly. So just finishing off then with the final hurdle of intentional homelessness. Moving to the next slide, please. So if the deeming provision has been found to apply, then clearly no issue of intentional homelessness will apply. Because if it's not reasonable to continue to occupy, you can't be at fault for leaving the property. But difficulties arise where the local authority find that it's not domestic violence as defined. In other words, it falls somewhere short of that, perhaps non-violent harassment, or perhaps actions which are explicable in the context of relationship difficulties. But this gives rise to a complex issue, in my view, of, well, at what point does the behaviour cross the line and become abuse? At what point is the definition satisfied? And how long should an applicant have to endure such behaviour before it's accepted that they cannot return? How long should they put up with abusive, coercive behaviour before it's deemed abuse? And that is a question that hasn't been answered by the present legislation or guidance, and I'm not sure it's been answered by the future and hopefully better legislative provisions that are coming into force. But essentially, decisions are being made on the basis that there was no reason for an applicant to leave. And just to leave you with a final example, it was held by a local authority that despite a partner having extramarital relations in the marital bed, that it was reasonable for the applicant to remain. And actually, she only succeeded in her homelessness case because she left. Was found intentionally homeless, but by the time the court came to consider it, the husband had moved in the mistress, and therefore the local authority accepted it wasn't reasonable for her to have to go back. But that's the extreme case of what survivors have to go through to prove that really they shouldn't have to put up with these very challenging and abusive relationships. So just to finish off on the final slide, changes to the legislation, in my view, are needed for the following reasons. A broad statutory definition of domestic violence is needed, and that's really to reinforce that abuse can be physical and non-physical, and that to give the definition a proper status rather than it appearing just in guidance. And I know Chris, again, will talk about the forthcoming definition. There needs to be the freestanding priority need category to ensure that survivors of abuse are accommodated. And something which isn't dealt with, but I think should be, is the evidential burden on survivors applying for homelessness assistance needs to be lifted. There needs to be a sympathetic approach. There needs to be properly trained specialist officers to deal with these cases. And it really shouldn't be difficult and arduous for a survivor of domestic abuse who has taken the step to leave their accommodation to then be assisted and accommodated. So that's the end of my part. Thank you very much for listening. I'm now going to hand over to Chris.
Thanks, Justine. And I'd like to thank Garden Court for not just putting on this series of events for International Women's Day, but also for inviting me to speak on my specialist subject tonight, which is domestic abuse. I'm going to look at the domestic abuse bill and what it promises, but also have a look at the wider climate in which domestic abuse now sits and how well the domestic abuse will address the problems that it raises. I preface what I'm about to say with the caveat that I'm making no criticism of any one part of the system, but rather I'm commenting on the impact of well over a decade of austerity and neglect on the ability of each part of that system to properly address domestic abuse in an effective way. But I want to start with some positives. So positives from the domestic abuse bill. Justine's mentioned the definition of domestic abuse. And I think a lot of us struggled as to why would we need one? Or it should stand to reason what domestic abuse is. But unfortunately, non-physical forms of abuse are routinely minimised, are not recognised as forms of abuse, and their impact certainly isn't taken account of in decision-making around safety for women and children, particularly women who happen to flee their homes as a result of that abuse. So I welcome the definition that includes coercive control, emotional abuse, psychological abuse, economic abuse, and gives them the negative status that they deserve, and also serves as a reminder to all of us and all services that we can't ever overlook them because of the damage that they cause to women and children who experience them. I should also make another prefacing comment that I talk about women and children because in 30 years of working with domestic abuse, I've specialised in working with women and children, and those are the people that I know and that I work with. So I'm not in any way suggesting that men can't be victims of abuse. Of course they can. My second in my top tips is the creation of a domestic abuse commissioner. And I really welcome Nicole Jacobs to the role. She's got energy, she's got great ideas, and it's up to us to support her and make sure that the role really develops and has a real impact on how really she's providing oversight as to what's happening on the ground, and we'll have to feed into that. I personally hope that her role will include data collection of decisions made in the domestic abuse arena in court, such as decisions that are made in the family courts around Practice Direction 12J. Frustratingly, change has been slow to those of us lobbying for it because we've got no data to support our anecdotal evidence. And that's because it's not collected. So we must make sure that the scale of the impact doesn't remain hidden, and we get that data that should be a driving force for change. Thirdly, special measures in court, again, very welcome, but it's not going to be available in all courts. And we do have it now. We do have special measures now. And what we're looking at is a position where we still have judicial discretion in the main for a special if special measures are going to be allowed. My number 4 is prohibition on alleged abusers cross-examining victims. Again, great. I would really, really welcome that, but I would want it to come in respect of all cases where domestic abuse is raised as an issue. Under the bill as it currently stands, it is mandated only where person A, the alleged abuser, has convictions or cautions for certain witness offences, such as witness intimidation, or where there's an unnoticed domestic abuse injunction in place. Then it's prohibited. In all other cases, it's judicial discretion. LASPO, when it came in 2013, decimated access to justice for victims of abuse, and it changed the scope and eligibility so that thousands overnight became ineligible for legal assistance in court. One of the perhaps unintended consequences of this has been the massive rise of litigants in person and the questions of parties having to cross-examine each other where there's been domestic violence or domestic abuse has been alleged. We know that an equal playing field is a fantasy because we know that any abuser in a situation where they are in court facing their victim or their survivor has a clear advantage, but cross-examination is only one part of the even playing field of justice between the abuser and victim, and prevention of cross-examination, in my own experience, will not be a panacea, I have to say that. I'm thinking about one case in particular where I represented a young woman who was adopting the baby girl, the baby child of her murdered sister. Her sister had been really brutally raped and murdered by the child's father, who was opposing her right to adopt the baby. The father appeared from strange ways by a video link, so you could say special measures again in that case. And even though the judge helped with the cross-examination by putting the questions to the father of the child himself, my client was still totally traumatised by the experience of even seeing him on a video screen across the court. I think if someone has already had to go to the difficult and sometimes humiliating process of getting evidence to prove that they're a victim of abuse to get legal aid, and that's a tough ask because you don't get legal aid easily, then I think it's disappointing that someone who's already crossed that gateway still has to require judicial discretion if they don't fit into one of the other categories. I think it'll help, but I'm sceptical about how much. My number 5 is we've got a new statutory offence, which is a big shout out here to the We Can't Consent to This campaign. It's been a really hard road. But now we can't consent to being seriously injured or murdered, for example, during sex, which should go without saying, really. But it's been a well-used defence by many men, and I'm sure you'll be as aware as I am of the ones that hit the press and the television media recently. So we now have an offence of non-fatal strangulation, which carries a maximum penalty of 7 years. So far, what's not to like? Well, moving on, my next point is domestic abuse bill and safe housing, which is part 7 of the bill. This introduces a new statutory duty on local authorities to provide safe housing for victims of domestic abuse. Supposedly, this is going to end the postcode lottery in finding emergency accommodation, which we all of us working in the field knows exist. It covers provision of refuge accommodation, specialist safe spaces, dispersal accommodation, sanctuary schemes, move on accommodation, which of course is pretty critical as well. And the support will include advocacy, liaison with other services, domestic abuse prevention advice, help with children, and counselling and therapy. And that sounds like a great package, and I really hope that that comes to fruition. I suppose my concerns about it, that I live in the North East, and my authorities are all Labour voters, and in those boroughs and in those councils, local authorities have seen their budgets slashed over a period of years to the point where we're all really struggling, and I make no bones about that. However, under the Act, under the bill, local authorities are going to be under a legal obligation to ring-fence funding for refuges. Again, great, but what's going to be the knock-on effect and what are they not going to be able to fund as a consequence of that? And I think all of that needs to be factored in. Bearing in mind that the Home Affairs Select Committee report on refugees recently stated that 60% of refugees were currently having to turn away women and children at severe risk of harm, we really have to hope that there's going to be a good impact from this and support it. Okay, my number 7 is priority need status homeless assistance to those who qualify, and that's under section 71 of the new bill. Hopefully, this is going to be really beneficial. I'm not a housing lawyer, and I'm hoping that one of the other housing lawyers can pick up the slack on this. But it will grant secure new tenancies to a social tenant who has or who had secure lifetime assured tenancy. And again, it's good but limited, and the green paper that's to follow will enable all victims of domestic abuse to obtain the same benefits where local authorities are currently offering short-term tenancy as a discretion. My number 8 is police powers. And again, I really scratched my head when I first read the first draft of the bill about this, because I have to say, the police have got enormous powers when it comes to dealing with domestic abuse. And those of us on the front line will tell you that the police are not using the domestic abuse notice powers that they have and they've already had before the bill. So I question the point of giving them these sort of supernova enhanced powers without a massive increase in capacity, which will allow them to actually put those into place. And that's something that's been picked up by the Bills Committee, and that's something that's going to be looked at further, I'm sure. So that's a quick romp through, but is any of this going to actually be the once in a generation fix that the bill promises? And I think to answer that, we have to look at how we deal with domestic abuse at the moment. And firstly, as Justine rightly said, during the pandemic, we've seen a rise in domestic abuse cases so huge that it's like nothing we've seen before. And I can tell you on the front line, it has been scary, the amount of demand for services. The Office for National Statistics have reported that between March 2020 and June 2020, police recorded 206,492 reported incidents of domestic abuse. That's a massive rise. We've also seen a massive rise in domestic homicide. Vera Baird, our victim commissioner, and the wonderful Karen Ingala-Smith of Counting Dead Women both raised the alarm at the start of lockdown when 16 women were killed in domestic homicides in the 3 weeks between 23rd of March 2020 and the 12th of April 2020. That's 3 times higher than the yearly national average. We're now having to get used to saying that 3 women a week are murdered by their partner or their ex-partner, whereas for years we've been saying 2 women a week. So there's a critical mass occurring here, and we need to look at how we're able to treat them. First of all, I'd like to look at how our courts treat domestic homicides, and in particular, I'd like to talk about 2 very brief case examples which show how differently our criminal courts treat women as victims. The first is the case of Ruth Williams. Her name was read out by Jess Phillips in the House of Commons today as part of the International Women's Day debate and part of the list of dead women as counted by Karen Ingala-Smith. She was killed by her husband at the start of lockdown. He strangled her to death because she was getting on his nerves, and that's the case report, that's not my interpretation. Her husband, Anthony Williams, was sentenced to 5 years in prison after pleading guilty to manslaughter on the grounds of diminished responsibility due to lockdown and depression. Now compare that to Emma Jane Manson, who was 28. She was being strangled. She was in fear of her life, and she actually thought she was going to die by her former partner, James Knight. He was really seriously threatening her and accusing her of infidelity. They were in the kitchen. She defended herself with the first thing that came to hand, and it happened to be a knife. She killed him with a single stab wound, even as he tried to strangle the life out of her. At her trial, she had a lot of psychiatric evidence of the impact of trauma, of the abuse on her and her ability to manage situations. And yet she was convicted of murder and sentenced to life with a minimum tariff of 17 years. So there is no doubt still a significant unconscious bias as to the way men and women are seen in the world and in our courts. For the domestic abuse bill to work well, there would need to be a magic money tree, I fear, because our starting point of capacity to deal with domestic violence at the moment is so low as to be subterranean. The Istanbul Convention became law on the 27th of April 2019. We signed the convention in 2012, and yet it's still not been ratified. In November 2017, the government said it would not ratify it until it was absolutely satisfied that the UK would fully comply with it. Well, that shows the kind of priority. The domestic abuse bill goes some way to meeting some of that, but nowhere near far enough. For me, the real promise of change over the last year has come not from the domestic abuse bill, but from the harm report about how the law deals with victims of abuse and their children, which was commissioned by the Ministry of Justice, although it was an independent report. An expert panel was led by Lord Justice Cobb, and it really, really got to the heart of the issue. I was so amazed when I read it in June last year, because it really did speak to what those of us working at the coalface know to be the lived experience of the women and children that we're working with. They identified 4 significant and overarching problems across every part of the system. Overwhelmingly, and no surprise, lack of resources was the first and the main of them all. We've got a justice system that's on its knees and barely able to manage the tsunami of children's public law care cases, let alone afford the time and care to deal with domestic abuse in private law. But also cuts to every part of the justice system, and our partners mean that we just don't have the resources we need to address domestic abuse. And to be perfectly honest, I see none or little of that addressed by the domestic abuse bill. I've mentioned cuts to the police. We've also seen cuts to social services, local authorities, CAFCAS. We've seen cuts to court sitting days. We've seen court closures. We're all well aware, I'm sure, of the impact of LASPO and the rise of litigants in person. The lack of available court time specifically has led to private domestic abuse cases being squeezed out to the point where the report states we've developed a pro-contact culture, difficult to say that, where contact is being seen as the most important outcome of cases coming before the court, contact for both parents, which they say minimises the impact of domestic abuse, it silences victims, and if they do try to protect themselves and their children by preventing contact with somebody they know to be a risk to their children, they themselves run the risk of being labelled as a parental alienator, and always the threat of losing their children to be placed with, to live with the abuser rather than them. And I think one of the things I welcomed most, and I really would like to see this reflected in the bill itself, is that we've seen a generalised inability to identify abuse and its impact on victims and children, and in particular, to understand and recognise the impact that the trauma of the abuse, has on the brain and memory of the victims. Unlike abusers, they're not always able to give what our courts recognise as and call cogent narrative accounts. In particular, they can't give a concise chronological history with dates and times, which our courts particularly like in terms of what they see as being credible evidence. The abuser, more often than not, and I say this from my own experience, can. So his evidence is very often preferred to the victims whose evidence may be confusing, it may be lacking in detail, and it may ultimately be found to lack credibility by the judge, or because of a lack of understanding of why that has taken place. I said at the outset of the inquiry when I first gave evidence about the bill that I thought the bill was largely window dressing. The bill was considered by the United Nations CEDAW Committee in 2019, and they said that it was aspirational but not realisable without a massive investment. And that was well before the seismic economic collapse that's been induced by the handling of the pandemic and the wasting of billions spent on crony contracts for things that don't work. And to put it in context, the government has just this week halved the promised pay rise for nurses from 2.1% to 1%. That's nurses, and in the middle of a pandemic. I do worry about how and where the money's going to come from that we need to actually make the terms, the changes that are set out in the bill actually come to fruition. And I sound all negative, but I do remain quite hopeful, and I will carry on fighting for this because it's so important. But I also want to mention at this point that just under the radar is the proposed plan to repeal the Human Rights Act and, of course, the decimation of the impact of judicial review. It's up to all of us to fight as individuals and organisations to maintain that we have access to justice for the most vulnerable in our society, because once those safety nets are gone, they're gone. That's it. And it really won't matter what the domestic abuse bill says at that point. I feel very strongly. We need specialist services, not generic services. And the issues of violence against women are complex. And the expertise in the front line, i.e. our NGOs and our IDWs, our ISVs, our refuge workers, must be properly funded as well. And their expertise must be properly valued and utilised. At the moment, we see routinely in court, day in, day out, judges and lawyers dismissing what they have to say from their years and years of brilliant experience as, well, they would say that, wouldn't they, because they support the victim, rather than recognise a professional who actually has something significant to say that may make an impact on the way a case goes and the result in court. The last thing I want to say, and I just want to say it because I feel so strongly about it, I'm so angry about it. An amendment was made to the bill to bring in special provision for women with no recourse to public funds who are particularly vulnerable. It was refused by the government, and it was refused at the same time as they were telling us that no woman would be left behind. Well, what does that say about those our most vulnerable in society, who have no recourse and have potentially homeless? It just makes me really, really angry. And I know Pravda's going to talk about it, so I'm just going to finish there because I know I've had my allotted time. So thank you very much for listening.
Thanks very much, Chris. So without delay, I'm going to just hand over to, I think Marina is next up. So thanks, Marina.
Thank you, Justine. I feel that I need a moment after that, Chris, just to sort of absorb everything you've said. There's a lot to think about, and it does feel almost the task is just so huge, and it's a worry. But I'm going to be relatively short. David, if we can just go on to the next slide. What I'm going to talk about is, and I'm going to try not to get over technical, is just some of the areas that, from a legal perspective in the housing world, would have been good to see in the domestic abuse bill, but we haven't. Chris ended her talk by referring to those with no recourse to public funds. It is the biggest omission from what I can see in the bill, glaring omission. It's just, there is no logic as to why it's not in there. It is not as if victims or survivors of domestic abuse are somehow less survivors, if you know what I mean. So to that extent, from a survivor's point of view, there is no logical basis for it. I refer to it in the first slide of my paper. What I'm going to do is bring in Liz at this point. I've made some notes in my paper, and of course you can look at those in your own time, but you'll see at the last bullet point, I refer to a case called Nkuban Brighton and Hove City Council, and in true Garden Court style, we bring you the most up-to-date law, because this decision was handed down about 2.5 hours ago, and the paper was updated to reflect that decision. It is an important decision, And we are very lucky to have Liz Davis with us today, who was one of the barristers involved in that case. Liz does not need any introduction, of course, but just in case you don't know, Liz is co-author of Housing Allocations and Homelessness Law and Practice, one of the go-to book for anyone practicing homelessness law. So what I'm going to do at this stage is, rather than listen to me talk about the domestic abuse bill and the lack of reference to no recourse to public funds, I'm going to very quickly pass over to Liz Davis, who has joined us to discuss the very recent decision of Nakub and Brighton and Hove City Council.
Marina, thanks very much. Thanks for bringing me in at 10 to 5 this afternoon. I will be brief on Nakub. Judgment was handed down at 12 o'clock today, and the Garden Court team of myself, Connor and Adrian, in fact, represented Shelter as interveners in the case. It's not about domestic abuse, but it is about what we colloquially call no recourse to public funds, NRPF, specifically in the context of homelessness. The test is whether or not they are eligible, but everybody refers to NRPF. You will remember that the Everyone In guidance handed down by the government at the end of March last year, just as we went into lockdown, said that local authorities should be accommodating rough sleepers because of the health risks that are connected with the pandemic for rough sleepers, both their own health risks and the risk, of course, of infection to others caused by people who are sleeping rough. And there were no conditions to that. So anybody who was rough sleeping and was not entitled to be accommodated by a local authority under Part 7 of the Housing Act, which Justine has taken us through, was entitled to this emergency accommodation as a rough sleeper, regardless of immigration status, according to the guidance. And then in May and in June, the government refined its guidance and said that, of course, the law on eligibility had not changed, and that local authorities should not be accommodating those who were not eligible unless there were, and it was a very, very tenuous reference to human rights. It was hard to be able to unpick the statutory and legal basis to that. Mr. Nakub is a failed asylum seeker. His opportunities of claiming asylum for the moment and for the purposes of this case have come to an end. He had been staying with his sister. He became homeless in September 2020 and went to Brighton City Council, where he had been staying. And they said, quite simply, well, you're not eligible under Part 7 of the Housing Act, which, leaving aside the details of his case, I mean, that was completely correct. And he spent about 6 weeks sleeping rough, mainly in Brighton train station, or outside Brighton train station. And eventually he got to first to a charity and then to lawyers. And the lawyers did two things. They quite correctly put in an application to the Home Office for Section 4 support because he was eligible for Section 4 support. But they also said to Brighton, well, while that is being sorted out, you should be accommodating him under Everyone In, under your powers to accommodate rough sleepers. And Brighton said, no, he's not eligible, that's it. So that judicial review was then heard in the administrative court on the 15th of December. As I say, Sheltered intervened. And 3 statutory powers were argued by the claimant and by Shelter that would enable Brighton to accommodate people who were not eligible under homelessness, and therefore it would not be under Part 7. The argument that I say didn't work, the judge decided not to decide on, was an argument that Section 1 of the Localism Act required local authorities to house ineligible rough sleepers where their human rights are due to be affected. The judge said he didn't need to deal with that. That was too fact specific. That is for another day. But what the claimant, Shelter, and now the judge identified is 2 statutory powers that local authorities have in order to accommodate, on the basis of an emergency, rough sleepers outside of Part 7 of the Housing Act. And the judge found that neither of those statutory powers was subject to the prohibition that they could not be applied to those people who are not eligible for homelessness assistance. The first of that statutory power is Section 138 of the Local Government Act, which is a power that local authorities have to provide assistance including accommodation, where there is an emergency or disaster that is a threat of life to inhabitants of that area. It's normally used for councils to move people away from areas that are about to be flooded and so forth. But in this case, the judge said it applied. And the second power is Section 2B of the National Health Service, which is the local authority's power to provide assistance, which the judge said could include accommodation, in order to promote public health. And in the context of a pandemic, our pandemic, the one we're living through, the judge found that there is an emergency. There has throughout the last year been an emergency, albeit that the tiers have gone up and down and so forth. And obviously that there are public health reasons for accommodating rough sleepers, as I say, both for their own health and for the health of everybody else. And that in those circumstances, local authorities do have the power to accommodate those rough sleepers who are not eligible. The circumstances in which the power can be used require the conditions in those two statutory provisions to be satisfied. So you do need to look at the judgment and you need to look at those statutory provisions. And for those of you who are housing lawyers, they're not terribly familiar to all of us. So you go and look at the two acts, and those provisions should not be used solely to circumvent the prohibition on eligibility. So they're not used just because somebody can't apply for homelessness assistance under Part 7. But if the conditions at the National Health Service Act or the Local Government Act relating to emergencies are met, then a local authority can provide accommodation, including to those who are not eligible, in other words, have no recourse to public funds. We don't know if Brighton are going to appeal. Obviously, they have 21 days to do so. If they do, some of the arguments will, of course, be reconsidered by the Court of Appeal.
Liz, thank you. I mean, for those who are wondering the connection with our topic today, it is that Pragna will, after this talk, discuss some of the people that she works with, some survivors of domestic abuse, and the real difficulties of trying to assist those individuals where they have no recourse to public funds. So it's a very, very important decision that I can tell you many lawyers have been waiting for. So David, if I can have the next slide, please, that would be great. Thank you. So what I wanted to cover very briefly, because I know the time and I know we still have 2 more speakers, but what I really wanted to cover is the current legislation's failure to really address a survivor's autonomy and a choice as to what happens to them as part of their homelessness application, and how the domestic abuse bill fails to address that or improve that in any way. Now, there's lots of examples under the current legislation of where that is the case, but I wanted to just pick up on a few that I've been seeing in my own practice. And the first is who is the responsible authority when providing accommodation for applicants who are survivors of domestic abuse? And secondly, what is considered to be suitable accommodation? So just dealing with the first, and again, without getting too technical, applications by individuals who are survivors of domestic abuse can be made to a local authority, who will then have to determine whether or not that person has a local connection. So if we start with the first 2 provisions that I've set out in the second slide, referrals under Section 19A, if you apply, for example, to one local authority, they will say, well, we are not the authority who is responsible for providing you with housing assistance. We will refer you to the local authority who is. And that local authority will be the local authority that you have a local connection to. So you will see there under Section 199. So looking at these provisions a little further, the referral cannot be made to the local authority that you have a local connection with if, and you'll see under Section 198 8C, neither the applicant nor any person who might reasonably be expected to reside with him will run the risk of domestic violence in that other district. So just purely by way of an example, if your applicant makes a homeless application to Westminster, but their local connection is in Haringey, they cannot be referred to Haringey for housing assistance if in Haringey they are likely to run the risk of domestic violence. Where is the local connection then? Which borough will a person be referred to? And that, as you'll see under section 199, a person has a local connection with the district of a local authority if he has a connection with it because he is, or in the past was, normally resident there, and that residence is or was of his own choice. Now, in the context of a survivor of domestic abuse, what is meant by one's own choice? And many of us who work in the world of housing and homelessness will know that, of course, many survivors don't have a choice when they're fleeing domestic abuse. It is not a question of sitting down and saying, well, I'm going to get a map out and I really like this particular borough and they've got lovely coffee shops and that's where I'm going to go and that's my choice. It's not reality. It's not how it works. And what's very interesting is that Chris mentioned earlier that under the Act, there will be an increase in refugees and that will hopefully address the postcode lottery that we are now seeing, with some areas having more safe houses than others. But in reality, a survivor or victim of domestic abuse will go where they have to go to flee the violence. Okay, that's what happens in reality. And those safe houses are not necessarily in areas that they particularly want. And there's relatively few of them, given the sheer number of people that are survivors of domestic abuse or victims of domestic abuse. And they have to take that accommodation. So most of us will be thinking that's not a choice in the true sense of the word. There is a Court of Appeal decision in 2013 that actually didn't quite agree with that proposition. And the Court of Appeal held that refuge accommodation can be accommodation of choice for the purposes of the local connection provisions. And that was a case where NJ was the victim of domestic abuse. She was living, I think, in Leicester at the time, and she decided to, let me just get my boroughs right, that's it, Leicester. She decided to leave Leicester. When I use the word decided, we know what we mean by that, to leave Leicester, and she took up accommodation in a refuge in Lambeth. Some months after she applied to Wandsworth as homeless. And her argument was, my connection is with Wandsworth. That is where I have formed networks. That is the area that I have friends. I am, of course, a vulnerable individual. I have been the victim of domestic violence, as the terminology was at that time. And the Court of Appeal held that in leaving Leicester and coming to London, she made a choice because she could have gone to another part of the country. And in leaving Leicester and coming to London and taking up occupation in that particular refuge, she made a choice. The court wasn't persuaded by the argument that was the only refuge that she could go to. The court was persuaded by the argument that refuge accommodation could be accommodation of choice. Now, I think in the context of the domestic abuse bill and in light of what Chris has been saying about the availability of refuge or safe houses, that decision will probably have to be looked at again. But what that shows me, certainly in terms of the cases that I've been in my practice, is that there's a real disconnect between the reality of a survivor's position and so-called choice, and how the courts are really interpreting what the purpose and function is of the Housing Act 96, whether it's under Part 6 or Part 7. Okay, the Housing Act is not designed to really consider the overall kind of picture, if you like. And I know Sue's going to come on and talk about this, or the complexity of the picture. The Housing Act is there to really, very narrowly, if you like, interpret the legislation in a particular way. So if I can just move on to the next slide. So just following this argument through them, once it's known which local authority there is a local connection with, the local authority will then have to, if the provisions are met, provide accommodation which is suitable. And I've set out in the first bullet point the relevant provisions in respect of that. Now, again, there is relatively little input from a survivor of domestic abuse as to what they consider to be suitable for their needs. The ultimate decision as to what is suitable is with the local authority. And although there is some guidance about considerations coming from a survivor, it's not codified in the way that we would have hoped. So, for example, under paragraph 17.6, the Homeless Code of Guidance, you will see that the local authority will have to take account of any social considerations related to the applicant and their household that might affect the suitability of accommodation, including any risk of violence, racial or other harassment in a particular locality. Where domestic violence or abuse is involved and the applicant is not able to stay in the current home, housing authorities may need to consider the need for alternative accommodation whose location can be kept secret and which has security measures and staffing to protect occupants. All right. Now, in practice, once again, the reality of the situation is that there is not enough refuge accommodation for survivors of domestic violence, and that is a real difficulty when trying to apply a code such as paragraph 17.6, but it's also clear that in practice, what we do see is that many of our clients are offered accommodation far, far away from their local networks, far, far away from their support networks. Now, their support networks and local support friendship groups or whatever it may be, or groups that they have made through their children's school, whatever that may be, may not necessarily be the same place that they have a local connection with. So it may not necessarily be the borough that has responsibility for providing housing assistance, such as in the case of NJ, where she was living in one borough, but her local connections were in another borough. That doesn't seem to be something the local, well, it is part and parcel of a local authority's consideration, but an individual's choice and an individual saying that this is really where I think I should be is not necessarily something that would sway a local authority. And an example of that is the case of SM and Waltham Forest. And this again is Liz Davis' case. So thank you, Liz, for raising this with me. Liz was successful in this appeal. And this is an interesting case because, again, it concerns a survivor of domestic abuse. And the council accepted that SM was homeless because her accommodation was not reasonable for her to continue to occupy, as it was likely that she would be subject to domestic violence from her husband if she remained in that accommodation. They made her, however, a final offer of accommodation in Stoke and Trent. And anyone who knows even very basic knowledge of geography know that Waltham Forest and Stoke and Trent are very, very far away. Stoke and Trent is not somewhere that SM had any connection with whatsoever. And she argued that it would be disruptive, not only, of course, to the family who had already been disrupted by having to leave their home because of domestic abuse, but to her children, I think one who was in the process of undertaking their GCSEs. In the county court, the appeal was successful, but Waltham Forest argued that the property in Stoke and Trent was offered, and if there was a real concern about domestic abuse from her husband, she would want to be as far away from him as possible. And therefore, in that context, Stoke and Trent was a perfectly suitable property to offer. And the judge rightly concluded, in my view, that although it was for the local authority to weigh up and balance the safeguarding issues with the disruption to the family, the reviewing officer should have taken into account SM's views when deciding what was suitable accommodation. Now, that's a very helpful decision, but again, in order to get to that point, an appeal had to be made. We had to go through the process, there had to be review, representations made, an appeal had to be lodged, and the appeal was ultimately successful. What we haven't seen, and in my view is a lost opportunity, is any attempt to codify that in the domestic abuse bill. So moving on to my next slide, if I may, David, I'll try to be very quick. What we see happening, and again, I've seen more of this, and I know that colleagues have too, is reciprocal arrangements, what I call a sort of parallel universe. And the way what's happening across boroughs in England is that local authorities are entering into reciprocal arrangements with each other. in respect of survivors of domestic abuse. In London, the reciprocal arrangement is called the Pan-London Housing Reciprocal and is operated by Safer London. And in practice, the way in which it works is that a survivor of domestic abuse can nominate a number of boroughs that they would want to live in or happy to live in, and then they go into presumably some sort of long waiting list in the hope that at some point they will be made a direct offer of accommodation in that borough. Now, there's relatively little known about reciprocal arrangements. What is clear is that any offer of accommodation made under reciprocal arrangements should be made under that local authority's allocation policy. Now, Pan London has stopped taking referrals. That itself shows you just how serious the situation has become over the last year. They have closed their referrals, and those who have been accepted have been waiting for a considerable amount of time. The reason I raise reciprocal arrangements is because this is a way of survivors of domestic violence having some choice over where they are housed in the long run, being able to nominate local authorities, give them some choice. Now, of course, there are difficulties with the reciprocal arrangements. The details of how they work are certainly not clear to me. And I think we need to do a lot more work on finding out how they do indeed work, but they're not codified. There are no statutory provisions governing how reciprocal arrangements work, other than the fact that when an offer is ultimately made, it is made under the allocation policy. Now, if this is happening amongst local authorities, and if survivors of domestic violence are being told that they can express a choice, they have a choice, why are we not then able to put this into the Domestic Abuse Bill by way of an amendment to the Housing Act 96? So if it can be done, if it is being done, there is no reason why it shouldn't come within primary legislation. So if I can have the next slide, please. I'll be as quick as I can. And this is my last slide. So what else have we not seen in the Domestic Abuse Bill, which we could have seen in some ways a lost opportunity? Well, the first is that Chris briefly touched upon this. The Domestic Abuse Bill does seek to insert Section 81ZA into the Housing Act. In short, again, without getting too technical, it means that where a local authority offers a tenancy to a survivor of domestic abuse, it will not be a flexible tenancy, it will be a secure tenancy. What we haven't seen is the Domestic Abuse Bill go as far as saying that where the local authority is discharging its duty to a victim of domestic abuse, then that should be or must be a secure tenancy. Secondly, joint secure tenancies. Family practitioners probably see this more than housing practitioners, but where there is a joint tenancy, that's a tenancy in the names of both parties, and one is a survivor of domestic abuse and the other is a perpetrator, quite often the victim will leave. And the implications of that is that the perpetrator, the abuser, is the person who's left holding a secure tenancy, which is, you know, in 2021, precious. They are, you know, not given out, and ultimately the perpetrator is allowed to remain in the property and has a secure tenancy, and it is the survivor who has to, of course, leave. Now, there may be very good practical reasons for that. Survivors often do want to leave the premises, but it would have been a welcome change to see a provision in the Domestic Abuse Bill that would have allowed survivors, if they so wanted, to have that joint tenancy put in their sole name, and for that to have been made easier. And lastly, and this touches on something that I raised earlier, it would have been a welcome change to see an amendment to Part 6 so as to prohibit local authorities, not LAS, as I've put in my slides, but local authorities from having a local connection requirement for those who leave their accommodation as a result of domestic abuse. We see a very different approach to this adopted by different local authorities. It will be good for people to know precisely where they stand on this issue, and it should have been, in my view, within the Domestic Abuse Bill. So I've rushed through that quite quickly. It's really just to highlight what could have been done in the domestic abuse bill, and as I said earlier, arguably a lost opportunity to make some of these important changes. I'm going to stop there and hand over to Pragna.
Thank you, Marina. I'm really honoured to have been invited here to mark International Women's Day, actually, with all these really amazing, distinguished panelists. I'm going to talk a little bit about the experiences of migrant women who have no recourse to public funds, mainly because this is a focus of our current campaign to include better protection for migrant women in the domestic abuse bill. The first thing I would say is that everybody recognises that, sort of long been recognised that addressing violence against women in the wider society requires a raft of measures, some of which have been talked about already, which include, sort of the housing options that have been discussed, effective civil legal remedies, robust criminal justice system responses, and extensive welfare options. Yet the same recognition is not afforded to abused migrant women who have immigration problems. We've long argued, in fact, that discriminatory processes within immigration law produces a double whammy for abused migrant women. They're not only excluded from state protection, but are also actually subject to state complicity in the violence that they experience at the hands of their abusers. At least 60% of the women that we work with at SBS have been subject to gender-based violence and have insecure immigration status. Most have arrived either as the spouse of a British national or someone who settled, or they come through other immigration routes. And a large proportion of abused migrant women have no recourse to public funds, which many of you will know is a condition of their stay in the UK because they're subject to immigration control. This means that they're not entitled to financial assistance from the state, including most forms of welfare benefits, including housing benefit and social housing, including from local authorities. This has a devastating impact on women's ability to leave or to exit abuse. Many of the women that we see have experienced physical, sexual, financial, and emotional abuse, but most of them are too scared to report their experiences to statutory agencies because they are totally dependent on their abusive spouses or partners for their survival. They're usually deliberately kept in a state of vulnerability and fear by their abusers, who will use their lack of status as a useful weapon of control and coercion. Abusers know that their spouses or partners have nowhere to go and no means of survival. And they often imprison women in the home or limit their contact with the outside world. And I have to say that our experiences show that women with insecure immigration status often face particularly heightened forms of harm and abuse. They're more likely to be imprisoned in the home. They're more likely to be subject to slavery or servitude. And they're more likely to experience very serious forms of harm. So faced with these challenges for the last 20 years or more, we've been at the forefront of campaigns and policy work to ensure that migrant women suffering domestic abuse or other forms of gender-related harm do not have to be stuck with the appalling choice of either staying in a violent relationship and risking their lives or that of their children, or leaving and facing destitution, deportation, and further exploitation. And as a result of that kind of long-term campaigning over many, many years, in 2002, we succeeded in compelling the then government to introduce the domestic violence rule, which allows women on spousal visas routes to apply for indefinite leave to remain in the UK if their relationship breaks down due to domestic abuse. And then another 10 years of campaigning and lobbying led to the introduction of the Destitution and Domestic Violence Concession in 2012. And what that does is it allows those applicants who are going to apply under the DV rule the chance to access limited state benefits and housing, whilst their applications for indefinite leave to remain as victims of domestic abuse are being considered. However, because of the restrictions placed on who can apply under the DV rule and therefore be eligible for the DDVC, most migrant women on non-spousal visas subject to no recourse to public funds continue to be excluded from protection. They have literally no access to food often and other basic items and lack access to an adequate welfare safety net. And this means that these women remain at high risk of abuse and harm. Indeed, there is evidence to suggest that BME women, including higher rates of suicide and homicide linked to histories of abuse. And there's recent evidence being carried out at the moment by the police who are reviewing homicides during the pandemic. And 8 months of data so far suggests that BME women are overrepresented in those homicide figures. What will be interesting to know is how many of those have insecure immigration status, but it's something that often domestic homicide reviews never actually identify. So the kind of difficulties that we face is, first of all, access to accommodation. It's a major issue, and we find it incredibly difficult to secure even refuge accommodation for women with no recourse, because refugees inevitably need to know how their housing and subsistence costs will be met in the long term. And indeed, even women eligible for the DDVC are often refused support in a refuge. Refugees are usually really reluctant to accommodate migrant women because there's no guarantee that their immigration status will be regularized and that they have, therefore, routes to other forms of support. And usually the other reason why refugees won't take in migrant women is because there's a delay in the processing of benefits, even if they're entitled to them, usually by the Department of Work and Pensions. Also, refugees refuse accommodation because supporting migrant women is resource intensive. Most have very complex immigration histories, and most refugees simply do not have the skills or experienced staff needed to support women with those histories or with those immigration histories. And a further difficulty for BME migrant women is the dearth of specialist BME refuge provisions, which have completely been decimated as a result of austerity measures. And that's partly, but also partly due to commissioning cultures that favor generic services over specialist ones that provide holistic services. Where there are women with children subject to no recourse, according to law such as the Children Act, local authorities are obliged to safeguard the welfare of children and other vulnerable adults. This includes providing accommodation and basic financial support. However, our experience shows that this is not always realized in practice for a number of reasons, mainly due to the cutbacks that local authorities have themselves faced, but also because of the absence of statutory guidance from government for those with no recourse to public funds. There really is considerable inconsistency of practice across the UK in terms of how local authorities respond in relation to no recourse families or women who experience abuse. And our experience and that of many others show that local authorities are regularly failing to meet their responsibilities to vulnerable adults, vulnerable families. On an almost daily basis, we are witness to the ways in which migrant women and children are turned away by local children's services. All too often, the domestic violence that women have suffered is often underplayed or just dismissed. Sometimes women are deliberately and disingenuously sent to another agency or borough or advised to return to their abusers or to their countries of origin without the requisite risk or needs assessment having been carried out. We've known cases where social services have offered tickets for women to return to their countries of origin. We've known social services to tell abused women that the children that they fled with should be returned to their abusers. And also we've known social services to give inappropriate immigration advice, including telling women to claim asylum, whether it's the right thing to do or not, because then they can obtain NAS support. In all of these situations, we frequently have to threaten to bring a legal challenge, both for the failure to carry out risk and needs assessments and for the poor quality of such assessments when they are often carried out. Single women subject to no recourse to public funds find it even a greater struggle to access social housing and welfare benefits. There is some limited provision available for some women under Part 1 of the Care Act in 2014 if they're assessed as needing care and support. Under the Act, if it appears that a person has need for care and support, the local authority must carry out an assessment. But the reality is that it is incredibly difficult to access this provision. Although the threshold for carrying out an assessment is in theory very low, our experience is that local authorities will often conclude that single women with insecure status and no recourse are not vulnerable enough to justify support being given under the Care Act, even when we have provided detailed evidence of domestic violence or abuse and vulnerability and indicated risk factors. For all these reasons, we're really disappointed by the recent government's pledge to place a legal duty on all local authorities, Chris referred to this, to provide secure refuge and safe accommodation to abused women and to end the postcode lottery. The announcement, if and when it is realised, will be of no use to migrant women that we work with, because such support constitutes recourse to public funds. So what have we done to try and deal with this really immensely difficult situation? Well, we've tried to ameliorate the real challenges that migrant women face by setting up a no recourse fund. So we use grants and donations to support women with no recourse in England and Wales. However, this is not a desirable long-term solution. Recent findings from our evaluation of the no recourse fund that we've been running for a number of years, which provides direct costs to abused women with no recourse, suggests that although providing housing and subsistence costs for just 3 months helps to avoid immediate destitution, it is nowhere near enough to give women who have often complex immigration and other matters the time needed to regularize their stay and achieve a sustainable level of safety and security. So this brings me to the Domestic Abuse Bill and the government's promise to deliver a landmark, in inverted commas, piece of legislation that supposedly will offer protection to all women. In reality, what we currently have is a bill that utterly fails to deliver anything of substance for migrant women. As things stand, abused migrant women are at risk of the most serious and prolonged forms of abuse, cannot access justice or protection if they have unsettled immigration status. They remain excluded from most of the protective measures that are contained in the bill. Along with others, we've been mobilizing resistance to the bill, now in the House of Lords, and demanding amendments so that migrant women are included. In particular, we've been calling for an extension of the DV rule and the DDVC to all migrant women and children, irrespective of their visa status, and for an extension beyond the current 3 months to at least 6 months or more. Despite a growing consensus that protection for migrant women is desperately needed, so far the government has resolutely rejected these and other amendments to the bill. And in rejecting our amendments, they have made 3 key arguments. First, they say that unlike women on spousal visas, other migrant women on other types of visas do not have a legitimate expectation of settlement. 2, they say that expanding eligibility for the DV rule and the DDVC to women on non-spousal visas could lead to an exploitation or misuse of the immigration system and of vulnerable migrants. And 3, they say there is a lack of robust evidence to support these amendments, and therefore they need better evidence. Yet none of these arguments actually hold up under close scrutiny. In relation to the issue of legitimate expectation, we have to remind the government that when the DV rule was introduced, initially as a concession, the stated purpose made clear in a parliamentary response to a question back in 1999 was that it was to enable abused migrant women who would otherwise remain trapped to leave an abusive relationship. There was no mention of legitimate expectation. It was about giving women a route out of abuse. And so, apart from being morally wrong, the government's response is wholly disingenuous and inaccurate. But even if we accept the legitimate expectation argument, there are many non-spousal visa migrant women who are subject to abuse, who have a similar legitimate expectation to remain in the UK. Many of these women have arrived in the UK as partners of those who settled, or they've arrived with valid visas and have the same expectation of settlement. And this category of women include, for example, partners of those who arrived as relevant points-based system migrants, or they may be en route to settlement with a partner who has limited leave. On this basis, they should also benefit from the DV rule and the DDVC when their marriage breaks down due to domestic abuse. The second claim that any reforms in this area might lead to an exploitation of the immigration system is a perennial one, but it has no basis in evidence. The DV rule and the DDVC have operated since 2002 and 2012, respectively, but there is no evidence whatsoever that either of these have led to an abuse of the immigration system. In fact, all the evidence points in the opposite direction. The assessment system put into place for the DV rule and the DDVC applications work effectively and have not been exploited. Otherwise, we would have seen changes or we would have seen them being abolished. And this government is not averse to changing immigration law in that way. So, for example, in response to parliamentary questions, and to give another example, in response to parliamentary questions in 2018, the government stated that 1,210 DDVCs were granted, out of which only 575 victims were subsequently granted leave to remain, demonstrating that there is an established threshold or criteria that must be met for someone to be granted leave to remain. And then the notion that extending the DV rule and the DDVC to other migrant women would lead to misuse of the immigration system by abusers is really, really nonsensical, given that abusers who support a woman to make such an application would in fact implicate themselves and expose themselves to criminal and legal proceedings, as well as provide women with access to protection and independence. So none of that would be in the abuser's interest. So we're not quite sure why the government thinks that it's okay to peddle such nonsense. And finally, the government's view that it cannot enshrine protection in the bill because of the lack of evidence about the needs of migrant women subject to abuse doesn't stand up to scrutiny. We and many other organizations have had extensive engagement with the Home Office over the last 18 months and more. We've given copious evidence in the form of oral and written submissions to the Home Office. We've attended meetings and given evidence at various parliamentary inquiries. So all that evidence has been deliberately ignored, misused, or misinterpreted. The government has offered a paltry £1.4 million pilot project to support migrant women for 1 year. And this is in response to a growing consensus now that something must be done to protect migrant women. And of course, the £1.4 million project is wholly inadequate. At best, it's only likely to provide minimal support to a few hundred women for a period of 3 months each only. Thousands of women will continue to be excluded, and there are no guarantees that following the completion of the project, lasting measures and new laws will be introduced to protect migrant women. So in conclusion, I have to say that the government's refusal to put into place meaningful support amounts to a continuation of the hostile, or now euphemistically called compliant, immigration environment. And despite the rhetoric of compassion that came after the Windrush scandal, the government's position is wholly at odds with its own legal obligations under the European Convention on Human Rights, the Istanbul Convention, and it also contravenes key CEDAW principles. It's also at odds with its own strategies and policies to combat violence against women and girls, including its own draft statutory guidance on domestic abuse that recognizes insecure immigration status as a significant risk factor. And in fact, we've heard that the government might ratify the Istanbul Convention, but enter a reservation in relation to the non-discrimination principle on the basis of migrant status. So we should all be worried, because all of this comes at a time when there are other deeply regressive moves afoot. Recently, the government announced its proposal to separate domestic abuse from the violence against women and girls strategy, and to create 2 separate strategies, one for domestic abuse and one for violence against women and girls. This dual strategy approach is, in our view, misguided, deeply problematic, and potentially harmful. It was announced without prior consultation and threatens to seriously undermine the efforts that have been made over the years to promote an understanding of all forms of gender-based abuse as part of a continuum of coercive control that is linked to gender inequality. So we fear that by separating the domestic abuse strategy from the violence against women and girls strategy, what we're going to see is the degendering of domestic abuse as we go forward. And this fragmented approach is really, really something to worry about. And all this comes at a time when Chris has said we're seeing so-called reviews into the Human Rights Act and judicial reviews. We should be very concerned, because they appear to be no more than a veil behind which this government seeks to dilute and ultimately to do away with the very legal tools that we need to help us to hold the government to account. I think I'm more and more convinced as I try to join up these dots that what we are seeing is a warning sign of authoritarianism, if ever there was one. Thank you.
Absolutely, Ragnar. It's a scary time in many, many ways. Sue, do you want to start your talk?
Hi everyone, and thank you, Golden Court, for inviting me to speak tonight on such an important issue and with such brilliant women. So thank you for that. I'm going to take you on a really, really fast whistle-top tour through holistic advice, basically multidisciplinary approaches to resolving legal problems, because I think they really suit dealing with domestic abuse cases in this way. So if you move to the next slide. So what does it mean? Well, people don't have single issue problems, but life events, an intersection of legal and other problems. And we can see that from some of the speakers tonight, some of the stories that Chris has told us. Legal research has shown that people are more likely to have 3 or more legal problems, and that they have them in clusters. And so we really need to address all of the issues, legal and non-legal, to make lasting change for the client and a more joined up approach to addressing legal need. So next slide, please. So some of you might know that my background is in housing law, and I'm not really talking about housing law tonight, but obviously very interested in what Marina and Justine were outlining before. But what I was seeing from my practice, that people were coming to me in crisis, and that we needed a much more integrated approach to resolving legal problems, and to get to clients earlier before they escalated. And I got a fellowship to travel to Canada and Australia for 6 weeks to examine multidisciplinary approaches to resolving legal problems. And the kind of what I was looking at in Australia was health justice partnerships, which have taken off extraordinarily well. And then in Canada, they have trusted intermediaries or trusted help. And so those were my focus. Next slide, please. And so tonight, I'm really going to talk about health justice partnerships, and they work by embedding legal help into healthcare settings in hospitals and primary healthcare. It's about collaboration with health services and the patients to address unmet legal need that is often causing harm to health. You know, people often don't know that they have a legal problem that can be addressed, and often they go to seek advice from their GP. And just as we have a strategic approach to public health, I think we have to do so with legal issues as well. And health justice partnerships are just one way that we can do this, because I think they shine a light on what is possible, and it's a model to do something bigger. So next slide, please. And what I'm going to do now is to show you a short video that kind of sums up what this is. So this is acting on the warning signs. This is a project in Melbourne, Australia. So David, when you're ready. It's just 3 minutes, so it's quick. Hopefully.
I was expecting my first child, and that's why I was attending antenatal appointments at the Royal Women's Hospital. Because of my past history, I was seeing a social worker at the Royal Women's, and she said that there is a lawyer here if you want to see a lawyer, because I was in a very violently abusive marriage and was still dealing with depression, anxiety, PTSD. I would not have seen a lawyer if there was not one at the hospital. Financially, I wouldn't have been able to afford a lawyer, and just the stress of going to more appointments while I was pregnant, I would not have seen a lawyer.
We know that healthcare professionals are often the first person that a woman discloses about family violence to. That in itself is the reason for us to do this. We are keen to understand and help our staff to be better prepared to address this issue.
As people would expect when they come to hospital, there's a doctor, there's nursing, there's physios if you need one, there's social workers. Now we're very lucky and in a position to regularly have a lawyer as part of our team.
My pregnancy would have been a real stress and struggle if I hadn't seen you, if I hadn't seen a lawyer. Like, it just would have been so stressful.
Women who are chronically abused, we know that they're often not allowed to leave the house. However, in many cases they will be allowed to leave the house for antenatal appointments when they're pregnant. So by having a legal service embedded into the women's hospital, where a lot of women attend for their antenatal appointments, it provides women with an opportunity to access information about their rights and entitlements in a safe place.
It enables you, in whatever your particular role is, to do your bit. It spreads the load. It makes proper use of all the expertise that's there.
We can provide them legal advice on some quite challenging and difficult issues, but do that in a setting where there are other services around them, such as social workers and caseworkers and other supports, to ensure that people are getting all the support and service they need.
She spoke to me in terms that I could understand. She was very supportive. She just did everything.
They provide an insight and a perspective that we wouldn't have known before, and vice versa. So to them, as a lawyer, they now understand the health side of things as well. And I think that that's the key to the partnership for this. I think the biggest advice is absolutely do it. There's no question that this is integral. It should be part of the healthcare system. I would advise anyone to absolutely take this step.
So I think they explain better than I could what you know, the purpose behind it is. So if we carry on with my slides, David, when you're ready. So that was acting on the warning signs, and that was the Women's Royal Hospital. And that was at the forefront of the health justice partnership movement in Australia with Women's Hospital, and something that I was researching before I went, and was kind of one of the reasons behind it, that I just thought it was a fantastic idea that, you know, go to where women are already accessing services, and we can make change that way. It's much broader than that, but obviously tonight we're specifically looking at domestic abuse cases. So through the partnership, the lawyers offered free legal assistance to inpatients and outpatients, but they also offered training. And as a result of the training to medical professionals, they were able to identify better and to then direct women who needed the service to them. So if you go to my next slide, David. The next project is Stepping Stones, and this is a lovely kind of project that shows how the co-location of financial counselling with family law legal advice really helped. You know, we know that women who've left violent relationships often are in debt or won't leave because of debt. You know, massively, we've heard from Pragna in terms of migrant women. But the debt is often brought about through economic abuse in the course of the relationship. The co-location meant that women could resolve their legal and financial options and make informed decisions, and eliminate the necessity of communicating with multiple professionals. They were also supported with appointments with government agencies. And the first findings, it's been running for about 4 years now, but the first findings were that, you know, all the debt in 25% of women were resolved and 45% partially resolved in others. So an amazing kind of project. And they brought in a social worker at the end as well, in order to kind of ensure that they got access to other appropriate services. And then if you go on to my next slide, David. So this was a really lovely project that I went to see in Alice Springs. So it's the Central Australian Aboriginal Family Legal Unit. And you walk down a road, it looks like a house on the street. They are just amazing. And this is what Phinia, who runs the project, says about giving advice to women experiencing domestic abuse. It's like a big jigsaw puzzle. It becomes apparent early on there is a legal matter to resolve, but there's also a housing, a mental health, a food and a disclosure issue. And for me, that kind of sums it up, doesn't it? And I think probably what Pragna would say is there are often an immigration issue as well. I mean, there could be employment, education issues with children. And what they do is they provide a complete package in terms of clients' needs, attending court, Centrelink, which is their kind of equivalent to DWP. How did I get that wrong? And refugees police stations, they go everywhere with their clients, and sometimes they're hundreds of miles away, so they have a car to assist the women wherever they need to go. And one of the other things that they do is she describes her lawyers as quasi-social workers, and they support people and work alongside their Indigenous client service officers who are integrated into the community. They go into towns, but they also go into schools, and they talk about consent, and they talk about you know, the whole issue around family violence, as they call it in Australia. So that was a wonderful project that I went to see. I mean, there were so many projects that I just can't talk about them. And as I say, I've got to do a whistle-stop tour, but you know, one day that I might just do one on health justice partnerships. But so what I wanted to do is to bring it back to England. In England and Wales, we've got a very small splattering of health justice. They're poorly funded, they're fragmented. And if you go to my next slide, David, what we were kind of looking at is the first point, the woman gets to you, the person gets to you at crisis point. So in this circumstance, it would be, you know, needing to leave the home or has left the home. So that's the crisis point. Then there's addressing the immediate need, which might be the emergency housing. Defending possession proceedings might be something. Injunction, exclusion order, trafficking, food, income. So those are the immediate needs. How do we address those for the woman? Because all of that, some of it's legal, some of it's not. The longer term needs could be longer term housing. You know, that the reason why we're here today is to talk around the kind of housing needs and how change needs to be made there. There might be benefit issues, immigration status, grants, debt advice, that kind of thing. And then the additional needs, there might be additional needs in terms of support for the children, support for educational needs, and then having ongoing contact. That seemed to be really key. And one of the things that Phineas said to me at the project in Alice Springs was that continued contact with the woman meant that in some cases, because of the family violence, because of other issues, children may have been kind of threatened to be taken away, but staying in contact and supporting the woman often made the change for having the children go back with her and having that consistency and that kind of input. So what did we do at Hammersmith? So if we go to the next slide, we haven't at the moment got a health justice partnership. It's incredibly difficult to do at the moment because obviously the pandemic. But what we have got is a women's crisis navigator, and that is Kate, who will be listening right now. We obtained funding from the Community Justice Fund last year to start holistic advice with the Women's Crisis Navigator. And this was an idea that Alex, who's our trainee solicitor there, came to the law centre. So big shout out for those two tonight. So Alex came to the law centre as a Justice First Fellow with a project to do holistic advice for women who are experiencing domestic abuse. So you can see that the Women's Crisis Navigator is in the middle there. She's the key contact and she navigates all the others. So in-house, we've got housing advice, we've got welfare benefits, we've got immigration advice. She's helping with support needs and where we don't have family advice at the moment. And so that is something that we have a partnership with solicitors outside of the law centre, but certainly something that we want to develop. When we thought about what Kate could do, we thought maybe she could be based in a refuge and helping women there. And then one of the things that we found out through research is that only 40% of women actually get to refuges. So how do you get to the women before they get to crisis? You know, that's the kind of thing. Can we get to women so they can make informed choices, that they can know their housing rights, know what benefits they can get, so they can make those choices before the crisis hits. So if we go on to the next slide, this is just our initial findings. We've got an academic in Australia, Dr. Liz Curran, who's looking at 6 months of the project and what difference it's made. So we don't have those findings yet. We're just, this is initially what we've got. So you can see that as a result of the advice that women are feeling that their trust has increased, their empowerment by 100%, and their anxiety, 80% there. So, in terms of supporting the women so that they're not falling through the gaps in legal advice, they're not just exhausted by travelling from agency to agency, that can make a difference. If you just go to my next slide, please. David, thank you. This was a lawyer that I met at First Step Melbourne. She says, for it to work, everybody needs to know a little bit about everyone else's stuff. a transfer of information as well as trust. And I think my job as a lawyer over the years, that trust is essential. It's something that we can transfer, and I've seen that happen with my own work with Ealing Law Centre and the Crisis Navigator there. But some of the stuff that I was looking at as well, and some of the things that came out from, I saw about 33 different organisations across Australia. But what struck me kind of the most was lawyers need to have empathy and work as part of a team. It was called preventative lawyering and compassionate lawyering, and I think those are really interesting concepts. And we have to value the input from other colleagues, which suggests formal legal training in a singular way. Needs to change. You know, working with nurses, working with social workers, doctors, and maybe valuing lawyers' time differently. The way that we cost it out at the moment doesn't lend itself to supporting women in a holistic way. So on to my next slide. Thank you. So as ever, things need funding. Peter Noble, who I've quoted from here, he's from the equivalent of our legal aid agency, used to work in a legal clinic, but in Australia, their legal aid agency actually provides legal advice and is completely different to our legal aid agency. And he says it's about recognising that legal issues can create barriers to wellbeing or create pathways to wellbeing, and telling that story better, more persuasively with government so that they value it differently. I'm not really sure that that's something that we can achieve right now with the government that we've got, because as my next sentence says, you know, it's an enormous challenge in the UK because we've seen the justice budget cut by 40%. But you know, if we can shift the narrative on the benefit of legal advice, that it not only defends fundamental rights, but can benefit people's physical and mental health, then, you know, it can make lasting change, but also it's going to make cost savings, you know, at the end of the day. So last slide now, thank you. So what next? The pandemic has pushed our services even more remote. I really feel that strongly working in a law centre over the last year. I really feel strongly that we can't just sit in our offices anymore waiting for our clients to come to us. And it is about building relationships and trust in a multidisciplinary way with a person-centred approach. And, you know, there's got to be a fundamental shift in how social welfare cases are funding, and having the value of a lawyer as part of a team, you know, not just somebody you go to see when you have a legal problem on its own. And that justice must be funded along with health and education, because it does have the potential to make lasting change for survivors of domestic abuse. So that's all I have to say right now. So thank you.
Well, thanks very much, Sue, and to all the panellists, and also to all you delegates that have lasted the overrunning by half an hour of this webinar. So thank you for staying with us. We just wanted to take a couple of questions that had been put in the Q&A box. There won't be time clearly to deal with all the questions, but I'm just going to pose two. And the first is to Chris, and this is a question by Hannah. I don't know if Hannah, you're still with us. But the question is, will the domestic abuse bill filter into other arenas? For example, perhaps reform the Sexual Offences Act. You were clearly speaking about filtering through. I just wondered if you could comment, Chris, on that.
I hope so. And what I can say is that there is a move to bring into law that victims of rape, for example, can have their own sexual violence complainants advocate, their own lawyer, to represent their human rights in court, because I think there's a growing recognition that rape and sexual abuse and sexual crimes are really the only crimes that come to a criminal trial where the victim is put on trial themselves. And the idea, this has been piloted in the North East, it worked really, really well. And it's something that's being pushed by the Victims Commissioner, Vera Baird. So hopefully we'll see that as a knock-on from this as well.
Thanks, Chris. Just another question, and perhaps Sue, you might want to take this. The question is from Amy. In high conflict divorce cases, many women are advised by their lawyers to stay in their family home or possibly lose their claim to it in a divorce. So there are many that stay in the home despite an abusive environment, which gets worse every day. Could you give your view, Sue, on how the two conflicts in the advice sort of can be married up, and perhaps speak about how the benefits of holistic advice might help someone in that situation?
Yeah, I mean, I'm not a divorce lawyer, so I don't know. I mean, in terms of transfer of assets, but that's the issue about having informed choices, you know, information so you can make an informed decision about whether to leave or not. So in that particular case, if the woman was able to get advice beforehand, then she might know that that actually isn't the case, that, you know, you can still leave and still get, you know, your share of the proceeds of the house. And I think probably there is a lot of misinformation around these things. And certainly something I saw on Twitter probably about 4 months ago, a woman had actually tweeted that she'd stayed for so many years because she didn't know what she could do. And it was at the point that she got some advice, and it was through a complicated means that she got the advice. But what that meant was she had this, you know, she made this decision having got the information she needed, and moved out of the property. And I think probably, you know, homelessness, accessing advice is really, really hard now. There are very few housing lawyers. There is a cross section, I think, that I think one of the reasons why, you know, so many people signed up today is because housing and domestic abuse family matters are, you know, it's complicated because it crosses both, you know, both housing and family. And I think there's a reluctance on housing lawyers to deal with it, and maybe a reluctance on family lawyers to deal with it. And certainly I've had many, many cases in the time that I've done possession proceedings of women turning up with a joint tenancy and they haven't seen the man for 10 years and don't know what to do. The local authority won't change the tenancy. And, you know, that's one of the things that I think, Marina, that you put in yours, and I think it's really key that to kind of getting the transfer of tenancy. So I'm not sure if I've answered the question, but I think it does go to the issue of getting information early so that informed choices can be made. I mean, I don't know, Chris, if you've got anything to say in terms of the house transfer. Oh, you're on mute.
You're on mute.
I was just saying that you've covered everything that I would have said.
Right.
So.
Can I just say, can I just jump in there on one point, Sue, that housing practitioners are familiar with? If there is a joint tenancy, one individual can end that joint tenancy by serving a notice to quit, leaving the other tenant without a tenancy. Now, if you have a really nasty partner who wants to do that, they can do that, and that ends that tenancy. And we haven't seen any attempt to change that again in the domestic abuse bill, and now would have been the chance to do it.
Thanks. So just one final question, and this is to Liz, perhaps a slightly ironic question from Jazz. I think it was posted for Liz. Would the decision in your case, Liz, have been different or not been made at all if we were not in a pandemic?
It's not ironic, it's completely right. And yeah, do not take this case too far. The judge found that the pandemic was an emergency and there were emergency powers in the 1972 Act. The judge also found that there were powers to promote public health under the National Health Service Act for councils, and that was relevant in this pandemic. This is not a judgment, as it currently stands, that says in normal circumstances all rough sleepers should be accommodated. Now, maybe we'll get there one day, and maybe this judgment is a small stepping stone to helping us to do that. But at the moment, it is very much on, well, it's on its own facts, and its own facts are in relation to this pandemic. That does not mean that the principles that it decides cannot be implied in other emergencies or other questions relating to public health.
If I could just come in, I wonder, Liz, if it's possible, because I was thinking exactly that how far could that work, say, for the kind of women that I've talked about. And I just wondered if it's possible we have a pandemic on our hands, and that's also actually raised another pandemic, which is domestic abuse. That's globally understood as a pandemic now. That in line with this emergency, we've seen spikes in domestic abuse reports, in homicides throughout the world. Globally, it's an issue. We are now in a situation that even post the coronavirus pandemic, whether we could be bold enough to say that domestic abuse now constitutes a pandemic, which therefore allows us to try and reframe the issue as a public health issue. This is probably totally far-fetched, but I'm just wondering how we can try and think creatively and differently about, in terms of going about getting these rights for women, which seem to be taken away more than delivered. But I just wonder whether there is time to argue. There's time now to argue that domestic abuse is a pandemic of sorts.
I mean, in the context of the Nakubi case, then one doesn't need to use the word pandemic. Because
but it's a big health issue.
It's so, well, what either you've got two possibilities. One is an emergency, and the emergency. So I'm just going to dip. Where's my copy of the? I put it away. An emergency that. An emergency or disaster involving a danger to life or property, so that which can affect all or some of the council's inhabitants. I can just see Southall Black Sisters putting together a submission to some of your local councils about the emergency involving danger to life of some of the council's inhabitants, and if so, they have powers. How they exercise those powers is up to them, subject to public law principles. But what we know from this case is that they are not prohibited from using those powers to alleviate an emergency or disaster because of NRPF status. And then the same analysis applies to public health. So absolutely, this is a building block for some more creative lawyering arguments. Yeah.
On that note, all I can do is say thank you very much for the panel to answer the questions that have been posed. Thank you so much to everybody who stayed with us for the extra 45 minutes. The slides and the recording will be sent out to all the delegates, so you will receive a recording, and we wish you all a good evening, and thank you very much.